The enforcement priorities are one of the major changes that this administration has made. They have added that priorities include anyone who's charged with a criminal offense and anyone who's committed an act that constitutes a criminal offense. Keep in mind, those two will not apply for people who have lawful status. You need a conviction for someone to be deportable if you have lawful status. That said, I think people should also keep in mind, though, that a conviction is not necessarily defined the same way by immigration laws. It's defined by a state. So some states might have some procedural ways of dealing with criminal issues that the state does not consider a conviction, but immigration law does. They have also added anyone who is subject to a deportation order at any time. This is a change from the Obama administration. They were just looking at people who had a deportation order in 2014 and after. So now we're seeing anyone who's ever had a deportation order. It could be a 20-year-old deportation order. On top of this, really, their priorities include pretty much everybody. They have essentially said that we don't care if you don't fall into these priorities. If you come into if you come to ICE's attention, you are subject to court and process and deportation. So these are things that have really concerned many of the folks in our communities. DACA, quick DACA updates. So we've had 3 district court cases that have issued injunctions against the administration to prevent the administration from ending the DACA program. So in January, we had California. That case was actually heard by the appeals court on May 15th, and we're still waiting for the Ninth Circuit Court of Appeals to make their decision on it. In February, we had New York, and then in April, we had DC, the District of Columbia District Court. That DC court was actually a little broader than the other two, because the California and the New York courts said that folks who have DACA or have had DACA in the past are eligible to reapply. The district court, however, said that they're going to open it up to new applications as well. However, that said, they decided to stay the decision for 90 days, so until July 23rd, in order to give the administration time to try and justify why they ended the DACA program. They have not actually been able to give a good justification since they announced the ending of it on September 5th. So I do not anticipate that they will provide a good explanation now. Temporary protected status. We are essentially seeing this administration saying, okay, we will extend all of these countries one last time, and then we're going to end it for everybody. So as you can see, the next one's coming up. We've got Somalia coming up very soon, September 17th of 2018. Sudan coming up on November 2nd of 2018. There's still a lot of advocacy going on around trying to make sure that the administration does extend these. There are also lawsuits going on, basically claiming that the government's claims and why they're ending these programs aren't actually valid, and that these programs should continue to be extended. The travel ban, of course, we just had the Supreme Court decision on the travel ban, basically upholding the administration's decision to ban immigrants and, in many cases, non-immigrants from certain countries from being able to get an immigration visa. Now, it's important to note this is only at the point of getting a visa to come into the country. Folks who have their green cards already are free to travel just like before. So as you can see, Chad, no immigrant visas and no visitor visas. B1, B2, those are visitors visas. Iran, no immigrant and no non-immigrant except FM and J. Those are essentially student type visas. Libya, same as Chad, no immigrant visas, no visitor non-immigrant visas. North Korea and Syria, they stopped all visas. Venezuela, they only stopped visitors visas for government officials and their families. Yemen, no immigrant visas, no visitor visas. Again, just like Libya and Chad. And then Somalia, they're only blocking immigrant visas. So non-immigrant visas, folks are still eligible to get those. And then the last thing I want to talk about, and this is a really important issue, is public charge. Folks might have heard about this. So first off, what is public charge? Well, public charge is part of what's called admissibility. Someone has to show that they're not going to be a public charge in order to be admissible to the United States. So in order to get an immigrant or non-immigrant visa. Not all immigrant visas are subject to this, by the way. But we were talking about, yep.
The distinction between immigrant and non-immigrant visa. An immigrant visa is one for some sort of permanent status. Non-immigrant is
right. So an immigrant visa would lead to a green card, whereas a non-immigrant visa allows you to come for a temporary period of time like for very specific purposes.
Right. Gotcha.
So really, public charge goes back decades in U.S. immigration law, and you're looking at someone who's likely to become dependent on the government for financial or material support. Under current policy, the only things they really consider when they're looking at public charge is someone who's, one, either receiving public cash assistance for income maintenance, and they're really looking at temporary assistance for needy families, supplemental security income or similar state or local programs, or they're looking at institutionalization under Medicaid for long-term care at government expense. And that's really it. They actually have a very long list of benefits that are not considered for public charge. And this is only a partial list I'm showing you here. But things like Medicaid, the state children's health insurance program, SNAP, WIC, housing, elderly care services, energy assistance. None of these things are considered right now for public charge purposes, and it's been that way since 1999. What they are looking at doing is to change the definition of public charge to anyone who is likely at any time to use or receive one or more public benefits. And beyond that, they're not just looking at the individual who's applying for admission, they're going to be looking at all of their family members as well. So someone who has a U.S. citizen who is receiving benefit, a U.S. citizen child, excuse me, who's receiving benefits, they're going to be looking at that to say, well, that parent seeking admission would be a public charge. All of those things that right now are explicitly excluded from the public charge determination would be explicitly included in the public charge determination. And even beyond that, because you can see on here earned income tax credits where the credit exceeds the tax liability. Also, they would be looking at people who receive tax benefits under the ACA as well. There's also a deportability provision. Under the law, under Section 237 of the Immigration and Nationality Act, someone who should have been determined to be a public charge, essentially, is deportable from the U.S. So this isn't just about admissibility. This can even apply to folks who have already gotten their green card. The draft regulations we've seen did not include any specific language on how this would work, but it did have placeholder language saying that essentially they are going to include this in there. Now, the important thing to know is that, again, this is not in place yet. This has to go through a regulatory process. So what happens is that USCIS will publish the proposed rule in the Federal Register, and we are expecting that sometime this month. That will begin a 60-day public comment period where anyone in the country can comment on this and say why this is a bad idea, or a good idea if you think. USCIS then has to take all of those comments and devise a response to all of those, and this can take many, many months. After that happens, they will then publish the final rule in the Federal Register. And the way the draft regulations we've seen work is that there would actually be a 60-day grace period after that, where anyone who's receiving public benefits during that 60-day grace period, it would not count against them. So not only is this, as the drafts we've seen have shown, not only is this not backwards looking, it actually includes a grace period after that final rule is published. So the one thing I would say is that we are encouraging folks not to get off of any benefits they're receiving now. The reason folks are on those benefits is because they need them. So we are encouraging people to stay on them. And that is it. I'm ready for questions.
Thank you, Sarang. And the questions are coming in fast and furious. And one of the first ones is, Jody wants to know, earlier on you said it's criminal offenses. Does that, misdemeanors included in that at all, or could it be?
That would include misdemeanors, but I would say this, that the sort of the intersection between criminal and immigration law can be very difficult, at least when you're talking about folks who have lawful status. If you're talking about someone who is undocumented, yes, misdemeanors would certainly be included in that.
Wow, and I mean, obviously, many of the attendees want to influence this proposed change, and I guess the only real way for them to do that is in the public comment period, right? What is there?
Absolutely. There is a national campaign going on called the Protecting Immigrant Families campaign. So if anyone's interested, that's being run out of the National Immigration Law Center and the Center for Law and Social Policy.
And just some very basic questions too, because I mean, there's just so much misinformation in this. It's so difficult to understand this
Indeed.
Alphabet of immigration policies. What exactly is a protected status?
So temporary protected status is, it was created in the 1980s, and the idea is that for people who are already in the United States, they can be protected by the government. What happens is that if their country goes through some kind of crisis, usually you're talking about armed conflict, natural disaster, the government will designate their country for temporary protected status. And then anyone who's in the country when the U.S. designates, who's in the U.S., I should say, when the U.S. government designates their country for TPS, can apply for TPS. And that'll protect them. It's usually done for 18 months, and then it's often been renewed. So we've seen some countries who've had it since 1999.
Right. I mean, it's been sort of the status quo to keep renewing some that status for several countries, right?
Absolutely, especially Central American countries.
And that status quo has totally been overturned.
Wiped away. Yep.
Yeah. The Trafficking Victims Protection Reauthorization Act. We have a question about that. Why does an undocumented minor with this particular status seem to have a case that processes longer than others?
It's frankly just part of the backlog of immigration cases. We've got over a 2-year backlog of cases right now. I would say it's not just those cases, those might be the ones you're seeing, but what they're doing essentially is that detained cases are on a faster docket in immigration court. And a lot of these cases, the children's cases, also have their own separate docket. So these are cases that are just being scheduled separately. And frankly, the courts are overwhelmed.
And there are a lot of questions about the benefits, and you said it's not retroactive. It's from a particular point onward, but they're also looking at even U.S. citizen members of the family. We had questions about, I mean, this affects anyone with permanent residency?
It would affect anyone who's applying for permanent residency. So that's the point. When you're applying for the green card is when this public charge analysis comes into play. Now, there are a number of folks who are not subject to that analysis. So for instance, refugees, special immigrant juveniles and such. However, when you see those people later applying for their family members, now it could come into play for those family members trying to come in.
Okay, and could you just give us a quick update on what's going on with our refugee intake?
Refugee numbers are essentially just frighteningly low. Now, they had said they were going to allow 50,000 refugees into the country in the year. They are well below half of that right now. Essentially, they have just downshifted the processing of these applications so that we have seen the number of refugees. I don't have the latest statistics, national statistics, but I do know we are well below half of that number of refugees for the fiscal year, which ends at the end of September.
And there's something like 65 million refugees in the world right now. And point to note that while the U.S. intake of refugees has plummeted, that's actually been a trend around the world right now. And so a lot of talk earlier on was about the U.S. being sort of the moral leader when it comes to taking in refugees. And obviously we've lost that moral leadership, and it's having a worldwide effect, right?
Absolutely, absolutely. It's hard to get other countries to take in refugees when we're saying, no, we're not going to accept them ourselves.